Talkshoe.
I'm here sniffing.
Recorded live.
Hello, everybody.
Rob, how's it going?
Good. I hope you guys all had a good Christmas and had a good New Year.
You good?
Yeah, just give me a minute. We'll get started. So. All right. Harvey.
Oh, did you mute us out or not?
Yeah, you're good. I'm muting everybody out. I'm bringing the board back in.
Oh, okay, cool. For a couple of days, the archives at Talkshoe were out for some reason. Now they're back on, which is good. So people can listen to the calls. For a while, it was showing forbidden or something. I don't know what it was. Anyway, if you're new to the calls and you would like to be kept in the loop, all you got to do is join the big list. All you do to do that is send an email to Rod, R-O-D, dash, class, C-L-A-S-S, dash, subscribe, S-U-B-S-C-R-I-B-E, at rayservers.com. And Ray Servers pretty much sounds the way it is. It's like a guy's name with his last name being Servers. So that's RAYSERVERS.com. And if you send an email to it, you'll be on the list. It's an automated list. It'll tell you when the calls are and when there are new private calls, etc. Anyway, just send an email to rod-class-subscribe at rayservers.com, RAYSERVERS.com, and you'll be part of the whole thing. That's basically it, Rod.
Okay, thanks, Harvey. All right, ladies and gentlemen. Basically, I've taken a sabbatical for a while on what we're doing. I'm working on some new paperwork on my personal court case. I'm going to keep a couple people that know I'm working with, Harvey and another gentleman, and we're putting some paperwork up, and I'm going to run it first before we put it out, because we don't need to give them a heads up of what's coming in before I get into court. But ladies and gentlemen, for you new people that's on the call line, do yourself a favor. Start at the latest and work your way back on the Talkshoe on the archives. Because there is so much information. And it's taken us a lot of years to be able to sift through the garbage that has been put out here by the Patriot movement, and some of the information that has been given out, had they have given the background historical history of it, it would have been so much better. For you new people, first time in court, get ready to go to court, and you're on the show listening. Ladies and gentlemen, do not attempt to try to walk in and pull bluff on these people with the information. Harvey gave you the website for the big list, and that big list has a lot of information on it. It has a lot of history, but because of its limited ability, some of the stuff that we did many, many years ago is no longer on there. But what you do need to do is get into the archives and start listening and start doing some research, because a lot of this can be found on the internet. A lot of it, if you will take the time, you can download the statutes at large off the internet. It starts out with volume 1 and goes up to volume 123. What we have learned throughout the years and what we're able to come back and improve is we're walking in here with the truth into these courtrooms. There's one thing that the court cannot handle. The court cannot handle the truth. It's not designed to handle the truth. It is designed, when you walk in here with it, to try to shut you down or sidestep you. A judge will come back and say, well, if you ask the question, is this the United States District Court or the District Court of the United States? And the judge will come back, I don't have to answer that. Yes, sir, you most certainly do. Because the United States District Court is a territorial court. It's a foreign sovereign immunity court. The District Court of the United States, which is the lower D.C., if you will look under Title 28 and go to Section 610, it defines the courts. You will see that the lowercase District Court of the United States, and then you will see the United States District Court as a territorial court. Ladies and gentlemen, it makes a difference on what courtroom you're in and what court you're operating under. These are challenges. The other challenge is the fact of what we have brought up here before we took off for Christmas vacation on the lies, the fraud, and the scam. There is no legislative creation for a lawyer. Now, I realize we have a tendency to interchange the word attorney for the word lawyer. So when you're talking lawyer, attorney, well, they're one and the same. No, sir, they are not the same. We have to change the habit on this, because under the Judiciary Act of 1789, which created the courts, created the Attorney General's office, and created the U.S. Marshals, the attorney, anytime you look up in the statutes or anytime you look up in the USC code, when it talks about attorney, it talks about the Attorney General's office. You will not see the word lawyer written in the statutes. The history of the attorney goes back to the Attorney General's office. It goes back to the Judiciary Act of 1789, but it can also be found in the United States Attorney's Manual under 3.2-110 history. And it will tell you that a meat, M-E-E-T, meat person learned in the law can be an attorney for the Attorney General's office. A meat person learned in the law. If you do the history on lawyers, they go back to 200 BC, before Christ. And a lawyer is nothing more than a next friend. It's nothing more than someone coming in, speaking on your behalf for you. Throughout the years, they created the Bar Association, to where now they have put the Bar Association in charge of who can speak into a courtroom and who cannot. Whether you are an attorney working for the Attorney General's office or you are a lawyer, you have to have a bar card to run their rules and regulations. That judge that's sitting on the bench was a bar member. So you have a conflict of interest already going into this thing. Under the Corpus Juris Secundum, Volume 7, at Section 4, still goes in and explains the duties of that lawyer on your behalf, goes back to the state and goes back to the court. And you're left out hanging. The book that one of the listeners sent over to me, The American Lawyers of 1907, pretty much goes in and lays a lot of this out and explains this to you. So if you sit back and think, in 1907, if they was having problems 107 years ago, we're still having the same problems today. Whenever you are operating in a courtroom, the issue comes up, are you facing an attorney or are you facing a lawyer in that courtroom? If you're operating to where it is the state of or the government, then you're operating with an attorney in that courtroom, which has legislative authority to be there through the Judiciary Act. If you're facing a lawyer from a banking firm or a lawyer from some other agency, then the challenge whether that person has a right to be in that courtroom now comes into question. Where is the legislative authority that allows this lawyer to walk into this courtroom? And the first thing that the judge is going to come up with is, well, he is a bar member, and being a bar member, that gives him authorization. No, sir, that bar association is a private organization, either to the state or to the federal government. And if we're talking the federal government, we're talking Title 36, Chapter 705, Federal Bar Association, a corporation. If you will look in your own state for the Bar Association, it was either created as an agency to the state, or it is created by the Supreme Court to qualify people that's going to come in and represent the state, that they're qualified to represent the state. That still comes back into a private organization, ladies and gentlemen. That still is a private organization. They don't have the authority to come in and deal with us in a courtroom. We need to challenge the standing, and we need to challenge the attorney or the lawyer in their standing in law. Because from what we have known and what this book puts out and what we have been told by lawyers that have been retired, by lawyers who never got their bar card because they were disappointed because when they went through this, they were never taught law. That right there is the key issue, ladies and gentlemen. They were never taught law. They were taught theory. They were taught concept. Now, I want some of you people to sit back and I want you to think here for a minute. What is the difference between theory and concept and reality? This is where the problem's coming in. Because these people were taught theory and law, and like we sit here and taught here, if you would go back and get into volume 43 of the statutes at large, and get into volume 44 of the statutes at large, and if you get into part 1 of volume 44, it will tell you that when the codes were codified, when the statutes were codified into codes, that they were prima facie. They are presumed to be the law. You can go back and do a presumption and sit down and says, okay, now, what I want this prosecutor, I want him to validate the law, and as we have known out circulating, Title 18 was never passed by the Senate. And if you will go back and do the history research, you will see that none of the USC codes were passed by the Senate. Now, what does this mean to you? Well, let's sit here and say that you're in a foreclosure. Foreclosure falls under Title 12 and Title 31, finances and banking. Under these circumstances, under these issues, if Title 12 was never passed by the Senate, then how can Title 12 for banking regulations apply to you, John Q. Public? And if you will look at Title 12 and get into Section 95, 95A, and 95B, and if you get into the annotated version, it will sit here and show you that the banking was under the Trading with the Enemy Act under Title 50, which is the state of emergency. If you will get into Title 12-411, it would define what a Federal Reserve note is. Ladies and gentlemen, these are some of the issues that can be brought up in your banking. Is you can pull out a Federal Reserve note and you can ask the lawyer, would you please tell the court what this is and what it says across the top? I want it stated on a record of what I hold in my hand. The judge will not allow him to answer that in court. And he will not answer it in court because the moment he says, well, that's a Federal Reserve note. Thank you very much. Could you tell me who is responsible and who the obligation belongs to? As you are practicing banking regulations and banking laws, obviously you know the Federal Reserve Act of 1913, Section 16. So please tell the court for on the record who is obligated for this Federal Reserve note. Same thing with IRS under Title 26, ladies and gentlemen. You challenge the lawyer for his validation. Where is there any legislative authority? Where is there any legislative authority for this man to be in here? Well, I represent the United States. Excuse me, sir. Are you stationed out of Puerto Rico? Is that where your home office is at, Puerto Rico? It's in the territory? Are you telling me that now we are in a foreign sovereign immunity court? Because you're from another country? Ladies and gentlemen, it takes courage to be able to walk in and go head to head with these people. It takes knowledge because most of this stuff in the courtroom, ladies and gentlemen, It is knowledge. It is understanding. It is better for you to have documentation in your hand because now you can bring up, says, excuse me a minute. If we are operating under the Federal Reserve notes, which we have here in our hand, let's talk about the 1935 Social Security Act under Title V, under Section 501, 502, which created a dollar amount for every live birth to be given to the state as a federal grant. Let's talk about the Alien Registration Act of 1940, which created the birth certificate, which certified the birth for the Social Security to give each state a federal grant loan. Let's talk about what this money is and where it's at and why isn't it paying any bills on our behalf as you put it on me at the time that I was born. Ladies and gentlemen, this is all in the archives. This is all in the archives. Not only that, let's sit here and talk about your standing. Are you an American citizen? They're going to say, well, of course we are. So, well, my understanding, under the International Organization Immunities Act of 1945, from the last time I looked it up in the statutes at large, it shows that your office was turned over to the UN. You're a UN national. Well, we're not going to talk about that either. Well, we have to talk about it because now we're dealing with a foreign entity. Because under Title 8, Section 1481 of the USD Code, you relinquish your national citizenship and took on the foreign agent side of this. And isn't it also true under Title 22 CFR under foreign relations is where the oath of office comes in, where you have to qualify for your position as an oath of office under foreign relations. Let's go back a little bit farther. Let's go back and talk about the 1967 Reconstruction Act that relinquished all state officials from their state sovereignty and placed them under federal jurisdiction of D.C. in 1867. Isn't it true that you are now a 14th Amendment citizen? Ladies and gentlemen, these are the frauds that we have brought up throughout the time on this show of giving you people information and knowledge, of being able to come in and defend yourself and address this stuff. This does not include the definitions under Title 26 at 7343 of the word person. And if you look under Title 26, under 7343, it defines the word person as an officer of a corporation or an employee of a corporation, of a trust and association. If you were to look up under agriculture, Chapter 7, and get into Section 136 and look up the word animal, the word man is a vertebrate. It is in the same category as a fish and a dolphin, as animals, ladies and gentlemen. Now stop and think about what I'm saying here. Stop and think here a minute. How are we being tried in court? How are we being tried in court? Because if you will go back and look, it starts out as the word person. And everything after the word person deals with the corporation. If you will look up, let me pull it up here. Because this is very significant of what we're getting into and what a lot of people have sit back and said their concept was right. Don't get me wrong. You know what? They didn't follow up with giving you the paperwork to back up some of the comments that they've said here and have said. Because under Title I, under Section 8, the word person, human being, child, an individual, also including born alive infants, human beings. I want you to look up in the Latin term, in Latin phrasing for human being, and it comes up as a lesser, inferior man or woman defined legally as an animal or a monster, as distinct from the ancient pre-Vatican Roman term homo, H-O-M-O, equals man. If you will look up let me find it here. That's that Title I under Section 8 for human. It refers you back to being an animal. Now, this creates a very serious problem in the courtroom. Creates a very serious problem in the courtroom. Because how are they bringing you in? They're bringing you in as a person? Well, that's a corporation. They're bringing you in as an entity? That's a corporation. Piece of property? That comes back under the bankruptcy side. That comes back under the Social Security and the alien registration as property owned. Therefore, that makes the court the trustee and you awarded the state, and therefore, they have to discharge. These are things that we have brought up throughout the last several years to you people to put together, to think about what's being said, to give you a line of defense in these courtrooms. You have to stop and think here a little bit. You have enough knowledge on AIB radio from the time we did this back in 2006 up to 2014. Roughly 8 years. You've got 8 years of knowledge of defined paperwork, of defined definitions of where this stuff is at, where to go look it up. For you to be able to walk in and go head to head in these courtrooms and challenge them. But do not walk in there empty-handed. Walk in there with paperwork in your hand, but also walk in here with this knowledge in your head and be able to speak it and be able to hand it down and lay it out as you're explaining it. Oh, you have doubt. Here it is. I highlighted it for you. They're going to come back and say, well, we don't run by laws in these courtrooms. Then what are you running by? If you're not running by congressional statutes, then are we running under Bar Association policies, which I am not a member, and I did not come here to join your club. The point in issue here is, sir, your prosecutor over here did swear an oath. He is under a paid contract. He is under obligation of contract to uphold and defend and protect the Constitution in this courtroom. That means he has to protect my rights. But what are you talking about? What part of the Constitution does he have to uphold? Well, let's talk about the fourth, Article 4 to start with, full faith and credit. Equal protection under the law from one state to the next. If this man has immunity, so do I. If this man can lie through his teeth, so can I. If this man doesn't have to follow the law, how can you hold me accountable for something that this man over here is flagrantly violating in this court openly? I also want to remind you of 63C2D American jurisprudence under public offices and employees. Ladies and gentlemen, you can download 63C2D American jurisprudence off the internet. I suggest that you do it. The reason why, because it goes in and defines their job duties as trustees. It also goes in and explains their immunities that they have. And it goes in and explains in their immunities. I'm going to give you two in a rough draft here, but basically what it boils down to is this. If they make an error in judgment, or if there is a mistake on their side, they cannot be held accountable for an error or a mistake. Anybody can make an error and anybody can make a mistake. Now, when they are knowingly and willingly walking in here and you're making the issue, excuse me, I want verification of the USC codes, because here on December 7th, 1925, when they said it was passed, I can prove to you that it was never passed. Because here's the statutes at large. Here is volume 43 that stops on March 4th, 1925. Here's volume 44, part 2, that starts up on December 16th, 1925. And by the way, here is part 1, and it tells you that this is only prima facie or presumed to be law. Now, we have an issue here. I'm being charged whenever it is presumed to be law. Now, I also want to make it clear under the National Industrial Recovery Act, when this thing was passed, the Federal Register was passed. The Federal Register was created by Congress so an administrative committee and the president could codify the statutes at large. Codify the statutes at large. And this was to be used for administrative agencies to hold them accountable. I will also refer you back to Executive Order 6174 of FDR, creating the administrative public works under volume 44. Unless the prosecutor can come back and prove the USC codes are not strictly administrative, then you have no claim against me in here. And if you cannot, and if you also have to provide the proof that if you're charging me as a man, it has me listed as an animal. A person is a corporation, and a corporation is a business. And the all-capital name that you brought me in here on falls back under Texas Administrative Code under Chapter 79, under 79.31 as an entity. And Delaware Administrative Code, Title 8, which is corporations, Chapter 6, Section 617, my last name is considered a corporation. So could you please tell me how you're dragging me in here? Because I am none of these. So would you please define the corpus delicti on my behalf? Who and what is a corpus delicti? Ladies and gentlemen, these are grounds to challenge the courts on. They can't come back and say you're a human being because you can go back and show under Latin, because the courts do operate under Latin, that the word human being is considered an animal or a monster. A person is considered an animal or a corporation, a fictional entity under Latin. Ladies and gentlemen, how are we being brought in? What is the corpus delicti? Who is the corpus delicti being brought in? These are questions that you need to start challenging them on and addressing this very issue. We have tried to break this thing down throughout the years of what we're doing to make things simple for you in here. It's taken us a long time to come up with all the information. We have come as far as what a lot of us can sit here and come, and it's like I've told Harvey, like I told a couple other people. From the time that we've been doing this since 2006 to today, we have basically walked you people down an assembly line on building an automobile from scratch. Little by little, we kept adding pieces to it. Little by little, we keep putting more on, and as you put on, you start to see an image of what you're dealing with. As you get down through the assembly line, and you start putting the motor and stuff in it, and the transmission and the wheels on it, and then you finally get the body on it, and you get the wiring in it, and you get the carpeting in it, you get the interior in it, you get the windows on it, you get the doors, you get the mirrors. By the time it gets down to the end of the assembly line, you pretty much have a finished product. You have enough sitting on this show for you to be able to go head to head with knowledge and expose the fraud in these courts. Now, the only thing is, once you get the automobile at the end of the assembly line, you got all the stuff that you need there. Now, if you want to put custom wheels on it, and you want to put window tint and chrome valve covers and headers, these are all extra luxury items that can be added to it for what you have, but you need the foundation. And we have pretty much worked this thing up through the whole foundation for you to be able to come in, to be able to go argument and go head to head with these people on this stuff. We're trying to get more people knowledgeable on this because we need more people to be able to step up to the plate to challenge the system. What we've discovered here in North Carolina is that the administrative court finally came back and said we had to name the city as the agency. And it makes sense because we went after the police department, we went after all the little departmentals, but you had to go after the main agency that deals with them, and that would be the city. And the best way to explain this is like you are going after the living room or the kitchen or the bathroom. That living room, kitchen, bathroom, bedroom is part of the house. So you have to go after the house. You just can't take out one room. You have to go after the whole house. When you're going after the police department or you're going after any of these inside agencies that belong to the city, you got to go after the city itself and sue the city. Same thing with the county. You got to go after the whole county because they are the ones who does the payroll. They're the ones who these people work for. They are the head agency, and it makes sense. So we've got a court case coming up in March, suing the city in an administrative court. Because the administrative court said we had to go after the city. Well, now we got the answer. So we're going to sit down and see how this works in March. But ladies and gentlemen, there is so much knowledge for you new people to get into the archives, to get in and start listening and start understanding and start doing some research. We try to sit down and tell you where the information is at. You will not hear me ever come in and say, well, just go in and tell them that you're not that corporate name and just leave it at that. Because the judge is going to ask you, if you can prove that you're not that corporate name, I'll dismiss your case. And ladies and gentlemen, that's what's got me started into this. Because many, many years ago, I was told, just go in and tell them that you're not that corporate name. If you could come back in and say, excuse me, let me explain to you, Judge, how this thing works. Under Delaware Administrative Code, excuse me, we're in Ohio. We have nothing to do with Delaware. Excuse me, sir. Delaware is the hub of the world for corporations. That has nothing to do with this case. It most certainly does because it tells you how you're bringing my name in this courtroom. So is Texas Administrative Code under corporations on that Chapter 79. You guys have it already in your computers, in your setup, that everything has to walk in here in all capital letters as a corporation. And you'll start laying this stuff out and start explaining it to them. They're going to try to stop you, but you object. Unless you can sit here and prove that I'm a corporation, because that's how you have my name spelled. Besides, let's talk about the style manual. And the style manual also gets into the capitalization. And the style manual is how you're supposed to operate in all legal documents. Look up the style manual. Under USPO, United States Printing Office, style manual. There's so much information here, ladies and gentlemen. There's so much that you can turn around and do, that you can debate, especially with what we talked about here on the word person and the word human being, and the word man being defined as a corporation or an animal. They're not going to be able to come back and argue this with you. How am I defined? Am I considered an animal? Am I considered a piece of property? At which point, if the attorney is the trustee, then he is liable. He now becomes responsible for any actions and any restitution or any jail sentence. That lawyer, I didn't say attorney, that lawyer now becomes responsible. Unless you're in there on your own, then that attorney now becomes responsible, because that attorney now has to sit down and define who and what is being charged in that courtroom. He now has to validate the corpus delicti in that courtroom. These are things that we have brought up throughout this show. All we're doing here tonight is doing some recap, doing some refreshing of some of your memories, especially some of your older people on here. We're just trying to get you to go back in. My God, you're right. We didn't think about that. That's a good argument. We're just trying to do some remembering, refreshing here. And for you new people, it's giving you another line to look at, because it's like I explained to my 8-year-old granddaughter here the other night when we got talking. My wife and I got talking about this, and my granddaughter asked me, she says, "Grandpa, what's the difference?" I says, you and I, when we're in school, and you're going through school now, you were taught that words have certain meanings, that if we were outside here among ourselves, we talk, we would understand it. But when you get into the legal society has changed the definition of the words to have different meanings depending on what room of the house you are in. We're in the living room. Man means creation of God, image of God. You go out into the kitchen, it means piece of property. You go back into the bathroom, it means an animal. If you go out into the kitchen, it means a corporation. The legal society has changed the definitions of the words, and because we are not up on it and we are not aware of it, this is how we're getting hammered. This is the significance. This is the significance of what we are bringing up to you. Some of the other things that you people can turn around and do is like I did here in North Carolina. We went back and we proved that the law enforcement, especially the sheriff department, has no legislative authority to pull you over. The job description and the duties for the sheriff department is to work as a bailiff in a courthouse. He is to serve paperwork on behalf of the court, such as summonses and warrants. Serve. I didn't say pick up. I said serve. The other part of his duty is to run the jail. So if he is to just strictly serve paperwork, he is to run the jail, and he is to be a bailiff in a courtroom, where is their authority to stop you out on the street, give you a citation, handcuff you, lock you down, and beat you with a nightstick? Go back, look in your state, look up the duties of these law enforcement officers. You will not find it's spelled out that they have the authority to do traffic stops. State Highway Patrol right here in North Carolina. Let me pull it up here. All right. The Wikipedia, it gets in, and it explains that their functions for their duties is to deal with any hijacking of transportation for commerce, and their duties lies with litter patrol. If you litter the street, that's their jurisdiction. Their job is to sit down there and go out and stop litter, and their job is to, in case there is a hijacking of a commercial truck. Now, did you hear me say that they have a right to give you a ticket and pull you over for a safety inspection? Did you hear me say that they can give you a ticket for speeding? No, you did not. Ladies and gentlemen, these are the things that you need to get in and look up in your state. These people are taking liberties here and filling positions that they legally cannot do because the court is looking at these people as revenue agents. This comes under the Highway Safety Act. Highway Safety Act comes under Title 23, USC Code, Title 23, CFR. But Rod, you just said that was administrative. That's exactly what I'm sitting here telling you. It's administrative. They can only deal with their own kind of people. We went back into Title 49 under 523.23 for automobile. Sits here and defines it for less than 10,000 pounds. Driver's license deal with anything over 10,001. These are things that you need to look up. These are things that you need to get into. And that driver's license and tags are under Title 49, USC Code, CFR. And the reason why, ladies and gentlemen, stop and think. These public officials are receiving wages, and anything that they drive is bought with taxpayers' sweat equity under that birth certificate. So they have to account for that property. They have to have a license to drive that state property to make them accountable if they have an accident or they do something wrong, that they have a license to drive it. Again, get into the National Industrial Recovery Act of 1933. Get into the Federal Register, 1935. It deals with licensing. It talks about their side, not you and I. It talks about them. But do not go out here and throw up your driver's license because, ladies and gentlemen, you're on a payroll. You need to go back and sue the state because you have not been paid as an employee. You have lost and had not had your hospitalization paid for. You haven't had your vacation time. You haven't had sick leave. Ladies and gentlemen, as long as you keep your license and your tag, you're a state employee or a federal employee, and you're entitled to wages. But again, this comes with knowledge of going back in and fighting them and going head to head with them on this. But these are all things that have been brought up. Get into Archive 741. 741 gets into the automobile side of this thing. This is a lot of the history, ladies and gentlemen, that we brought up for all of you to hear, for you, all of you to understand, for you to learn. Freedom is based on you standing up for it, not someone handing it to you. They have railroaded us for so long, and we have been sheep for so long that we have been sheared. They're so used to shearing. They're not used to someone coming in here with a set of antlers instead of horns. They're not used to somebody coming in here with a set of teeth. Part of what we're trying to do here, ladies and gentlemen, is do the private attorney general side on that stuff. Bringing charges against them, holding them accountable for their wrong acts, bringing up their screw-ups, pointing out their errors. This goes back into where you have to know their job. You have to be able to define their job for them and tell them what their job is. You're in the United States District Court. Well, sir, we don't use the laws. Excuse me. Are you familiar with Title 28, 1331, where there is a federal question and constitution and laws and treaties? Are you familiar with Title 28, 1652? Any acts of Congress are supposed to be upheld in this court? Are you familiar with Title 28, 610? Defines what the different courts are? If you're telling me all this is frivolous and all this is unintelligible, then what you're telling me is that you're not running under any congressional legislation. You're running under bar policy. Again, I'm not in here as a member, and I'm not applying for membership. Challenge the attorney. Challenge the lawyer. They don't have answers, I'm telling you. They don't know this stuff because they were never taught. Download, and you can download it on the internet. It's the American Lawyers of 1907. Download the book, read it. It's like 255 pages long. Go read the book and the enlightenment that you will get on this. Because this was a lawyer that actually wrote this thing out. He was frustrated in 1907. And that means it had to be happening long before that time period. And like I said, we're in 2014, 107 years. What you're complaining about today, you'll find it in this book 107 years ago. But ladies and gentlemen, there's a lot of history and a lot of knowledge. We've got into the 14th Amendment citizen side of this thing, to where the 14th Amendment citizen came in 1868. But under Chapter 15, or 15 Stat 249, was the expatriation that took you and I out of that 14th Amendment side. The 1867 Reconstruction Act put all public officials over to that 14th Amendment side. Where you and I got drug in at was not under the 14th Amendment. Where you and I got drug in at was under that 1933 bankruptcy of when they stripped this country of its gold. And they created the Social Security Act of 1935 and the Alien Registration Act of 1940, where they put a dollar amount value at the time that you were born and gave the state grant for every live birth. That's where it started. That's where the name come in. That's where people are mistaking that 14th Amendment citizen. That's not a 14th Amendment citizen. They stole our identity. This is how and when it started. This is where it started. That 14th Amendment only stripped the state officials and put them over to the federal side, giving them a foreign status set up to the federal government. Because the federal government is subservient to the state because the state created the federal. But thing of it is, ladies and gentlemen, under the 10th Amendment, you and I created the state. If it wasn't for the people, if you sit back and you think about some of these old-time cowboy movies, I know some of you sit back, well, what's that got to do with anything? If you sit back and listen to them, many, many times they have brought up shows in order for this to be a state, the people has to get better organized. We've got to stop some of the corruption within so we can get out of the territorial side and become a state. The people have to set the state up. Ladies and gentlemen, you and I start the state. We are the creators of the state. And the state is the creators of the federal government, which makes them a creation. And the state is a creation. We are the creators. I know for some of you new people, it's going to take time. Don't jump before you go back and get educated. Don't walk into a battle. Sometimes it's better to pay the fine and come back and fight later than it is to walk in here with half knowledge and get your butt handed to you. Let me take in a caller, and I'll be right back. Virginia, go ahead.
Hey, Rod, how you doing?
Good.
Good. Two things, Rod. I got into the United States Style Manual under capitalizations.
Yep.
And I noticed that it said that any time that, I guess, like you said, the district court is in lowercase.
Yep.
I interpreted that to mean that when they put District Court of the United States, they aren't really referring to a specific United States District Court. Let's say they aren't really specifying the one in Virginia or the one in Maryland or the one in Pennsylvania. What they do when they use the lowercase DC, and again, this is just my interpretation, they're referring to all of the federal courts in those territories at one time. You follow what I'm saying?
Well, that's what they were. That's the point. Throughout the statutes at large, when they first created a court, it was lowercase District Court of the United States, and that was the Article III constitutional side of this thing. And then in 1940 is when they went to the United States District Court. That's when they switched over to the corporation side, over to the territorial and foreign sovereign immunity side.
Okay.
What they're doing is they are switching the name going in here, because if you go back and look under Title 28, Section 610,
right,
you will see that the lower D.C. United States District Court, but when you look at the United States District Court, it's the capital U, capital S, D.C. And if you will look at the United States District Court, when you walk in, it's all capitalized. That's the corporation side, and they're not disclosing any of this.
Okay. Okay. Another thing here. I'm in Virginia having some issues, and I was just doing some investigation. And what I've discovered is that there is something that's called the Inspector General, and I'm sure every state has one. And I went to the website, and it says that the Inspector General's responsibility is to investigate claims from either state employees or citizens of that particular state if they suspect any fraud, misuse of funds, or abuse of policy. So here in Virginia, they have what's called the Virginia Process Act. And any time you have an issue with one of these agencies and they deny if they find you guilty of something, then in that decision that they give you, they're supposed to include statement of facts, findings of facts, and conclusions of law. That's part of the Virginia Process Act, and every state has one. So when they don't do that, they're basically violating their contract that they have with the state. And here in Virginia, there are different departments which are under the executive branch of government. Now, when it comes to the Department of Transportation and the Department of Motor Vehicles, those fall under the jurisdiction of the Department of Transportation. Now, underneath that, what happens is that the Department of Motor Vehicles, they set up what's called a state program, okay? And that state program funds the Virginia State Police Department. And that police department is out really to enforce the Department of Motor Vehicles highway safety standards, the federal highway safety standards, which is under the Highway Safety Act. And you and I both know under the Highway Safety Act, that deals with commercial vehicles.
Correct.
Okay, so I'm saying all of that to say this, that if everybody gets into their state, they'll see that every state has executive departments, and those executive departments, they set up state programs, and then it's through those state programs that they set up these private corporations, such as the Virginia State Police, that they fund in order to carry out federal mandates. So everything is federal, and everything that they're enforcing has to do with commerce.
Correct.
So, I hope that helped explain it to other listeners out there. So, but again, that Inspector General, that you may want to look into that, because that's an avenue that I'm going to take if the city of Richmond doesn't honor a claim that I put in for them violating again the certain acts on the Virginia Process Act when they denied my appeal, which I eventually won. I went to court and they dismissed the case. So now I'm going back and asking for compensation under a code that Virginia has that allows for a party who received a favorable decision to come back and ask for recovery of costs.
Okay, that sounds good.
So, okay.
All right, thank you.
All right.
Bye-bye. Southeast Texas, go ahead. Texas?
Hey, Brian.
Hey.
To go along with that guy there, he's hitting the nail on the head. The finding of facts and conclusions of law goes along with the affidavits under pains and penalties of perjury and warrants. Now, we got a recent case down here in Texas where the guy, I've been working with him for 20, 25 years, he told the judge, he said, I'll pay the fine. I'm not going to dishonor the state, the corporate state. I'll pay the fine as long as the finding of facts and conclusions of law is put in the record. How am I going to pay a fine anyway, and especially without a finding of facts and conclusions of law according to your rules? And the judge said, well, why don't you write the finding of facts and conclusions of law? He said, it's not my job. It says that you will write the finding of facts. How could I write them? Well, he walked out, and the prosecution and the clerks and all that, well, what should the fine be? Da, 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 da. And he said, well, I guess I'm free to go. And they said, yeah, you're free to go. In other words, finding of facts and conclusions of law is just as important as the warrants under pains and penalties of perjury and, the affidavits under pains and penalties of perjury and the warrant. If you're found guilty, there needs to be a finding of facts and conclusions of law. And if it's not there, then there's nothing that you can move forward with unless they can, blow smoke up your behind.
Yeah.
But, Rod, you kind of worried me there one time. This is another subject, but you said, well, we've just about come to the end here unless something else comes up. And I'm going, oh, no. Rod, please don't ever quit. Hammer this stuff in. I about got it memorized, but, I'm still learning, just like you are. But please don't give up as long as you're breathing.
Well, the thing of it is, we have come down to where we've showed to people that no lawyer can walk into the courtroom because he's nothing more than coming in as the next friend. We've come in, we've showed where the USC codes hold no standing because they was never passed on December 7th. Just because they was publicized on June 30th, 1926, publication doesn't make them law. Also coming back in, and what we are addressing on the bar side of this thing, of them coming in, they got a conflict of interest here. Like I said, though, we've come pretty much to the conclusion on all this stuff, but we are still bringing in. There are still some issues that we need to hammer on, get people to understand. But once you bake the pie and you get it out of the oven, there ain't much more due to it other than put whipped cream on our ice cream and eat it.
Well, they pretty much got it back in 1988 with me. Is that he was put in the spot. The court-appointed attorney was put in the spot because I was going to say, where's the affidavits under pains and penalties of perjury and warrant? Which you've done, and then the prosecutor wants to act stupid in D.C. and say he don't know what that is. Well, that's totally asinine.
Well, see, that's the whole thing, and that's why we got to come back in, and because they want to play ignorant on their side of the fence. Well, ignorance is no excuse, and that's what we need to come back and remind them. If this guy doesn't understand this, then he doesn't have the authority to bring any claims or any action, because under the phrase of corpus delicti, he has to have received the injury.
Exactly.
All right? Yeah. What he is doing, even the prosecutor, ladies and gentlemen, the prosecutor is bringing in third-hand information. He does not have first-hand facts.
So you nail his ass.
All he has is hearsay. Now, the point being of it is, even under the circumstances, is the fact that, well, you had firearms. Excuse me, sir. Do you know the definition of the word firearm? Did you take an oath to the Constitution, and did you swear that you would uphold the Second Amendment? Or do you know what full faith and credit is? Equal protection under the law? There's just so much here to hammer and hammer and hammer on these people.
I don't want to blow your cover, but, you're setting them up. You already know all this stuff.
That's the whole...
I didn't want to blow your cover. If a guy down here in Beaumont that's a 45-year-old lawyer that knows that he needs to stand up when the court is violating the prosecution and the judge is violating due process on my end, and if he doesn't stand up, I'm going to expose the court-appointed lawyer, and he knows all this stuff. I've gone over this in past calls, and you know what I'm talking about.
Yeah.
He stood up and he protected himself because he was going to be held, just like you said a while ago. He was going to be held under the American Jurisprudence 63C. Was that A and B or C and D or what? C and 63C?
Yeah. 63C, 2D, American Jurisprudence.
He knew that. I didn't know that until I started listening to your show. Then I went, wow, this lawyer knows. And he even had the book open, Texas statutes that said if there's no warrant or affidavits, the case is to be dismissed immediately. And I looked over there and I went, whoa, this guy already knows that. And then when the judge found me guilty and sentenced me, the court-appointed attorney already had the appeal bond made out, and all he needed was how much is the bond, the appeal bond. He said $1,500. And he wrote that in there. There was no money paid, because there is no money.
That's all credit off your birth certificate side of this thing.
Yeah,
that's all they're running off of. They're securitized, because we went back and we have shown in previous shows that they have you sitting on the stock market. You used to find yourself on Dun & Bradstreet. You used to find yourself on Fidelity. You used to be able to go into Bloomberg. Well, they have now closed all these windows unless you are a member, that you can't get into any of this stuff anymore. But nevertheless, they have sold you, and that's why this stuff is important for you to turn around and bring up.
Yeah. See, back in '88, I didn't know none of this stuff, but you brought it all out. So all of these cases, and all of you people that are listening in, all of your cases are wide open. Because, you have a right to be informed in all state constitutions, the code of ethics, what's right. You have a right to know what's going on. And what are they doing? All these magic tricks, right, Ron?
That's exactly right. They're not disclosing anything. They're not coming back in and telling you that the USC codes hold no merit, because you aren't supposed to know any of this. And this is where you could come back in and you could challenge them on the laws, because we sit down and said a long time ago, there has to be an enabling rule in order to do it. But ladies and gentlemen, stop and think here a minute. When you're walking into that courtroom, they only want to deal with one subject matter at a time. Whenever they pass laws, and I want you to get into the Ohio Constitution under Article 2, Section 15, subparagraph D, when they pass a law, it has to be of one topic, one subject matter, one issue. Now think about what I'm sitting here saying, because when they tried to pass the USC codes in 1925 under H.R. 10,000, they tried to pass all of them at one time. Now you stop and think how many different titles you have, and all the different sections you have, and all the different chapters you have, has kinds of different topics. How can they possibly pass all of this on a one topic, one issue, one subject matter? Ladies and gentlemen, that's one reason why they could not pass H.R. 10,000, because it was not in conformity with the rules. And if you get into the Jefferson's manual and you read the Jefferson's manual on how they're supposed to pass laws, they couldn't pass it anyhow.
Rod, I hate to interrupt you. Did I interrupt you?
Go ahead.
Okay, but around 85, somewhere between 85 and 88, we were going to the law library, about 4 or 5 of us. I said, look, all this shit was passed in 1925 in the state of Texas, you know? I said 25. And then when you come up with this, they passed all this federal crap, and they didn't pass it, but they presumed that it was law prima facie. I said, I'll call all my buddies. I said, Rod's laying this shit out. All the states did the same damn thing that the Congress did. Senate didn't pass it. They just published it and presumed that it was law. And that's the same way the state, at least in Texas, and it's probably every state in the union. It's all prima facie, right?
Correct.
In 1925, the same date you're talking about, or soon thereafter. Maybe go back.
But this is the whole point. If you go in and actually get a hard copy of your statutes or your codes, if you go through the first part of the book in the preface or in that area, you will probably find prima facie law written all over this thing, like you do the USC codes and the CFRs and all this other stuff.
I got someone going to the archives in Texas here to get certified copies of when and if it was passed properly, and it's not going to be done because we already have the evidence anyway. We just want to get certified copies from the archives of how it was done.
Well, that's the whole point. It has to be passed by both houses, and it has to be an enabling rule act on this, and it had to be bonded.
They ain't done shit. Nothing.
That's exactly right. And this is why everything falls back under the administrative side. It only applies to their side of the fence.
Exactly.
For you new people, understand here, I'm not saying that there is no laws, okay? Don't misunderstand what's being said here. There are laws. We have laws among ourselves that we don't trespass on one another.
Exactly. So, trespass, not trespassing. You're right. Trespass is for living souls. Trespassing is for animals. And we're not animals.
We're not. So we don't trespass on each other's rights of what we're doing. We come under the common law side, because when you injure me, I'm now the corpus delicti. I'm now the injured party. Not the state, I am.
You're using the correct terms, and you're doing well with that. And that's what the people need to listen to, is that the correct terms versus how they taught us to speak in school or college. The school for fools, what I call it. The public fool system.
Exactly. All right, let me move on. We got a couple more people. Thank you.
Thank you.
Illinois, go ahead. Illinois?
Hello, Rod.
Yeah.
Yeah, this is Rob from Illinois. Real quick, I sent you part of those notes from Carl Lentz on how he had his sister handle that prosecutor, and I can resend them to you. But going back into what the prosecutor not having firsthand knowledge of the facts of the matter, another question could be asked, and it doesn't even need to be asked, but to back that up, the fact that they don't have firsthand knowledge is you can ask them, where were you on the morning or the afternoon or the day of this incident when it happened? They weren't there at the time it happened. So
that's exactly right. So he's not given, and the thing of it is, it goes right in to where whoever they would bring in as a witness Now you can go back and challenge them, because the moment you start bringing the law up, the judge is either going to say, well, they're not required to know the law. That now presents a problem here, because if they're not required to know the law, then they can't bring charges. Because you will find most police officers are not taught law. They are just taught go do, and the prosecutor will cover it and protect you. Because there's been too many times I've got into a debate with them out here, and I started quoting the law. Well, we don't know anything about that. We don't know anything about that. Excuse me, what do you mean? Aren't you law enforcement? Aren't you supposed to know this? Isn't this part of your job description?
Hey, Rod, I don't know how far you've gotten with this. Have you gotten anywhere in the courts with bringing any of this up to them about the fact that the codes were never brought forward correctly?
Right now, I'm not going to get in to talk about my case, okay? Because I know they're listening, and I'm not going to give them. What we're doing here is covering the history of what we've talked about. And like I said at the beginning, I've taken a sabbatical. It's Harvey and another gentleman and myself. We're putting some paperwork in, and we're going to see how it flies and see how they handle the paperwork. And we're not going to get what it is.
Yeah, because the reason why I ask is, I mean, you're right about the history, and if you can get it to the point and fine tune it and make it work in court, that's great. You already know this, and most people listening to the call that have been listening to you for this long know this, is when you hit them upside the head with their own codes and statutes, that's something they can't get past.
No, they can't, and that's a very serious issue, because they can't charge you with something that they cannot explain.
Right, and they have a hard time getting that past a jury of sheep out here that look and say, well, your own codes say that you can't do this, so why are you people doing this? I had a friend who hired a guy to get him out of this red light camera ticket, and this guy showed them in their own statutes where they were wrong, and with the red light camera, and they're like, they got rid of the ticket. Instead of ruling on the statutes, which would have created a precedent, they ruled, oh, he made a stop. That's how sneaky these people are.
Well, yeah, they'll find ways to get around in order to cover themselves, because they don't want to come up guilty on this, because they don't want to face a lawsuit. And this is all the more reason why, ladies and gentlemen, it is up to you to get knowledgeable
Recorded
to start
live.
bringing major lawsuits in against these people. Hello, everybody. Because there is a one-third bounty here.
Guys, now I had a good Christmas.
And the judge says, now, well, what do you want? Well, what I want is I want this man's bar card, I want his property, and I want everything sold, and I want 2/3 of it given to the United States Treasury, because this is the bounty side of this, where the Treasury has to be paid because this man didn't do his job right, and I get a 1/3 finder's fee out of this. If you try to take the whole thing, then they can come back on you. But if you give 2/3 to the Treasury to pay it off, then they can't argue with this.
Cha-ching, cha-ching.
Yes, definitely.
Yeah.
Okay, let me go to the next. Thank you.
Okay, thanks.
All right. Harvey.
Oh, did you mute us out or not?
Texas, go ahead one more time. Then we'll go ahead and get because we're an hour and a half into this. Go ahead.
Board back in. Sorry, Rod. That guy out there just brought up another thing.
For a couple of days, the archives at Talkshoe were out for some reason. Now they're back on, which is good.
You need to go
so people can listen to the calls. For a while, it was showing forbidden or something. I don't know what it was.
Yep.
Anyway, if you're new to the calls,
that's a big deal right
and
there.
You would like to be kept in the loop, all you got to do is join the big list. All you do to do that is send an email to Rod, R-O-D,
about the traffic ticket and the stoplight,
class, C-L-A-S-S, dash subscribe, S-U-B, S-C-R-I-B-E, at rayservers.com. And Ray Servers pretty
plead
much
to
sounds
something
the
that
way
I
it is.
didn't
It's
do,
like a guy's
much less
name,
the charge that I did,
his last name being
that I didn't,
Server.
that they accused me
So
of
that's
originally.
R-A-Y.
The prosecutor put it in writing.
VERS.com.
And there's no.
And if you send an email to it, you'll be on the list. It's an automated list. It'll tell you when the calls are and when there are new private calls, etc.
I said, well, put that in writing and sign it.
Anyway, just send an email to rod-class-subscribe rayservers.com. RAYSERVERS.com, and you'll be part of the whole thing. That's basically it, Ron.
I made an affidavit under pays and penalties of perjury of what he did with a witness affidavit in his office.
I've taken a sabbatical for a while.
This is what he offered.
What we're doing.
He's made an offer called
working
an
on
offer
some new
contract,
paperwork,
which was
my personal
actually subordination of perjury, which is
a
a felony.
People that know.
Try to get someone
with Harvey and
he's
another
a
gentleman.
Attorney, and he's trying to get someone to
some
plead guilty to
up.
something that they didn't do, much less what they were accused.
I'm going to run it first before we put it out.
I put it in the permanent record
because we don't need to give them
what
a
he
heads
did.
up of what's coming in before I get into court. Well, see, this is how they operate. They will try to plea bargain you to something else in order to get them off the hook, and that's all the more reason why we have to go in and nail them with their own statutory law and make us as proof on the Talkshoe on the archives.
Yeah,
because there is so much information.
They blow them out of water, and another thing,
and it's taken us
on the internet. I looked up a long time ago that it's something like a law and order if that
has been put out here by the Patriot Movement
within 1 year, if he gets a legitimate
some of the information
due process violation
that has been given out
sent to the state bar or the American Bar
given the background
that goes to the
history of it.
If he gets one,
it would have been so much
year,
better.
If I remember right,
for you new people,
can no longer practice
first
law.
time in
if they're
court,
not insured, they can't practice law.
Get ready to go to court, and you're going to show, listen, ladies and gentlemen,
what is a law firm has been in business for 3 to 5 years, they get 3 complaints.
You try to walk in
and
pull bluff on these people with the information.
Lose their insurance, and they can't.
Harvey gave
like you say, the IRS,
the website,
the people's
for the big list, and that big list has a lot of information on it.
All those embezzling. The insurance company
has a lot of history
for the bar card,
but because of its
holders,
limited ability, some of the stuff that we did many years ago is no longer on there.
And all they're doing is practicing fraud.
But what you do need to do is get into the archives. But see, the other thing that we're looking at here is if you, we got the paperwork here on the Chris account. This is the court registry. A lot of it, if you will take the time. CRIS, Court Registry Investment System, the statutes at large. This goes back in, and it shows off the internet that the pension and retirement, it starts out with volume 1 and lawyers come out of this. Well, now this comes into a very serious issue of a conflict of interest, because for what we have brought up in past shows is that these lawyers have to sign a non-disclosure with the Security Exchange Commission.
Isn't that with DPS and
we're walking in here with
tickets also?
Well, yeah, but basically what we're talking right now is one thing that the court cannot handle. The court cannot handle. If the attorneys, upon graduation, once they get their bar, they have to sign a non-disclosure. We can't sit down and tell the people that we are investing in these cases and we are getting dividends on the side, and this is where our retirement is coming from. Because if we told the people this, what would happen if the people knew that this is what we were doing? Court of the United States.
Yeah, and what they're doing,
I don't have
what
to
answer. Like,
yes, sir, you most certainly do.
Dun & Bradstreet and Bloomberg, they're shutting it down for the people
because
go
the
into
United States District Court is a territorial court. You got to buy membership into it. Now it's coming down. You got to be very precise of exactly what you're looking for, because we've got too close to the United States, which is the point being of it is that there is
If
now
you
a
will look
vested
under Title
interest
28
in all these lawyers and judges in these court cases.
and go to
and
section
if they sign
610,
a
it defines the
non-disclosure
courts.
with the Security Exchange Commission,
You will
for
see
you
that
people
the
who
lower
don't know what
case
it is, the
district
Security
court
Exchange Commission
of the United
is
States,
the head of
then
all
you will see the
securities.
United States District
They're
Court
the
as a
ones who go
territorial
in
court. Ladies and gentlemen,
and
it
do
makes
the
a difference
background and do
on
the
what
checking
courtroom
and
you're
see
in and
where
what
the
court you're
signatures are
operating
being
under.
sold, how many times the signatures are being sold, how much investment is involved in
These
in
are
your
challenges.
cases. The other challenge
You can get that
is
information
the fact
under
that what we have
Open Disclosure
brought
Act,
up
Freedom of
here
Information Act, or something like that.
before we
the Records
took off
Act
for
request.
Christmas vacation on the lies.
But they're not going to
the
come
fraud,
back in and
and
sit
the
down and say,
scheme.
oh, well, now that you ask us, yeah, because the reason
There
why you're
is
going to lose
no
in here because we made $100,000 off you by losing.
Ooh-wee.
Or $1
Creation,
million,
or
or $2
a
million,
lawyer.
or whatever.
Now,
Because
I
what we
realize
sit down and prove
we
here
have a
is
tendency
this one kid that we
interchange
worked
the
with
word attorney
finally got out here after 3.5
for the
years.
word
He's
lawyer.
never had a trial, never went to
So when you're
arraignment.
talking
They kept him in
lawyer,
jail for 3.5
attorney, well,
years.
they're one and the same.
But
No,
2
sir,
years
they are
into
not
this,
the
is
same.
close to 2.5.
We
They
have
have
to
made
change
well
the
over
habit on this
$600
because
million
under
off this kid sitting in
the
jail.
Judiciary Act
got
of
the evidence and the facts on
1789,
that,
which
right?
created the court.
I got the guy that's got the evidence on it,
Created
yeah, because he went in, they got into
the
Security
Attorney General's
Exchange, and they
office
pulled
and
out the
created
court
the
case
U.S.
and how much the
Marshals.
county made.
Somebody's in deep doo-doo.
The attorney, anytime
But see,
you
this
look
is
up
the whole
in the
point. This is
statutes
what I'm sitting there
or
saying,
anytime
this
you
is
look
stuff
up in
that
the
we have
USC
brought
code,
up
when it talks
in
about
past history on this
attorney,
show.
it talks about the
What we're
Attorney
bringing up
General's
tonight
office.
isn't something, this is the first time being said.
You
It's
will
been brought
not
up
see
on
the
previous
word
shows.
lawyer. This is just a recap
Written
of
in the
getting some of
statutes.
you old people to sit down and think here what was said, and new
The
people give them
history
some
of
new
the
information.
attorney
This
goes
is a
back to the Attorney
mind-boggling
General's
recap
office.
because Rod has put it in such
It goes
a
back
way
to the Judiciary
where
Act of
it's condensed.
1789, but it can also
You're going
be
to get it in
found
detail
in the United
in the
States
previous
Attorney's
stuff.
Manual
in detail.
under
But
3.2
I like every show, Rod.
110
Wow. Please keep
history.
hammering. Thank you.
All right, thank you.
And it will tell you.
All right, ladies and gentlemen, I'm going to cut it early
that
here
a
tonight for what we've done.
M-E-E-T,
It's been a
meat
sabbatical
person
for me for what
learned
we've gotten
in the
into.
law.
I've been working on my own case.
And being an attorney, you know, we're coming
For
up
the
with some
Attorney
new
General's
avenues
office.
here, and I've got
meat
to
person
test them,
learned in the law.
and I've got to be able to run them because
If
those
you do
that
the
know
history,
me knows I'm
on
the
the
best one who
lawyers.
can walk, talk, and
they go back
put
to
this stuff
200
out
BC
and go
before
head to head
Christ.
with these people. For you
And a
newer
lawyer's nothing
people,
more than
get
a
into
next
the archives,
friend. It's
ladies
nothing
and gentlemen,
more than
because
someone
I'm
coming
telling
in.
you, the amount of knowledge
Speaking
and
on
the
your
wealth
behalf
of
for
information, you can't buy this stuff.
Throughout the years,
You can't
they
go
created
out
the
to
Bar
any
Association.
college and learn what
Where
we're
now they
educating
have
you
put
on this show.
the Bar Association in charge of
The
who
money
can speak into a
for
courtroom and
you
who
to have
cannot.
to go out and buy this
Whether
information,
you are an attorney working for the
couldn't
Attorney
afford to
General's
buy it.
office or you are a lawyer, you
but
have
it's
to have
all
a
been
bar
given
card
to you
to
free
run their
of
rules
knowledge.
and regulations.
Go back and download. Go do the
That
research.
judge that's sitting on the
Go
bench
look
was
this
a bar
stuff up
member.
for yourself.
So
The
you have a
USC
conflict
codes
of interest
are on
already
the
going
internet.
into this thing.
CFRs are on the internet. The statutes at large
Under the
are on the
Corpus
internet. All you got to do is go
Secundum,
download
Volume 7.
and go hunt.
At Section 4,
Get into the annotated. The
Still
ones that
goes
you
in
pull
and
up for the
explains
USC codes got notes. Push on the word
the duties
notes,
of
because
that
gives
lawyer
you the
on your
history
behalf.
of what that law was written on. What's the foundation?
Goes back to
what
the
was the
states
basis?
and goes
of it? Where
back
did
to
it
the
come
court.
from? Why was it created? What's the
and
history
you're left out
behind
hanging.
it? That is very important.
The book
of
that
what the
one of the
foundation of what the
listeners
USC
sent over
codes
to
are
me,
based on.
the American Lawyers of 1907,
But tonight, ladies and gentlemen, was
pretty
just
much
a
goes
recap
in and lays a lot of this
what
out and
we've done
explains this
over
to you.
the period of years.
So if you
to
sit
get
back
you
and think,
to do your
in
research,
1907, if
get
they
you
was
to
having
start
problems
standing up for your rights,
107
because,
years
ladies
ago,
and gentlemen, it's your freedom.
we're still having the same problems today.
Your freedom is worth dying for.
Whenever you
And
are
I sit
operating
down and be
in a
nasty,
courtroom,
no, because, ladies and gentlemen,
the issue
Arlington
comes up:
Cemetery
are you
is
facing
full
an
of
attorney,
veterans that died for your freedom.
or are you facing
You got a lot
lawyer
of veterans in this
that
country come
courtroom?
back disabled. You got a lot of veterans come back.
If you're operating where it is the state or the government, then you're operating with an attorney. Your freedom
has value. Your freedom
which has legislative authority to be there through the Judiciary Act.
I have talked.
If you're facing a lawyer from a banking firm,
alphabet people,
or a lawyer from some other agency,
after they went back and did the research, their attitude,
then the challenge whether that person has a right to be in that courtroom now comes into question.
Because they realize they've been lied to. Here in North Carolina,
where
I got
is
other
the
people working
legislative
with me here in
authority that
North Carolina.
allows this
They went to the
lawyer
sheriff
to
department.
walk
They went to
into
the
this
police
courtroom?
departments, and they're bringing out and showing,
And the first
they're
thing
starting
that
to see
the judge is
changes
going to
in
come
the
up
system.
with is, well, he
Because
is
they've
a
been
bar
lied
member,
to. They've been
and
frauded.
being a bar member, that gives him authorization. No, sir.
Education,
that bar
ladies and gentlemen, is where
association
it's
is
at.
a private
Knowledge.
organization,
Not all of you are going to be able to speak it
either
like
to
me.
the state
Not all of you are
or
going to be
to
able
the
to
federal
quote it and
government.
run
And
it
if
off
we're talking
like
to federal government, we're talking
It's
Title
taken me
36,
a lot of years to be able to
Chapter
get this
705,
position. A lot of years.
Federal Bar
I didn't learn this stuff
Association,
overnight.
a corporation.
If you would have asked me back in 2001,
If you will look in your
on
own
December-
state for the
on
Bar
February
Association, it was
27th,
either created
I would have
as
laughed
an
at you.
agency to the state,
February 28th, I got a
Or-
very rude awakening.
it is created by
From
the
that time
Supreme
on, I've
Court
learned.
to qualify
I've
people
studied, I've
that's
educated
going to
myself.
come in and represent the state that they're
Because
qualified to represent the state.
I am the best
That
one
still
to
comes
walk
back
into
into a
courtroom
private
and defend
organization,
myself.
ladies and gentlemen.
Because no attorney will bring up any of this stuff that
That
we're
still is
bringing
a
up.
private
Number one,
organization.
He cannot. They
If he
don't
does
he
have
gets
the
disbarred.
authority to
His
come
job
in
is to cover up for the state. His job is to protect
and deal
the
with us in the courtroom.
prosecutor. That if he makes any errors, it's his job to make sure
We
that
need
errors
to challenge the standing,
don't get let loose, and that he
and we need to
sits and
challenge
protects him and sells out his client.
the attorney
That's how this works.
or the lawyer in their standing
I
in
want
law.
to thank you for being in here tonight. I appreciate you
Because
being
for
in.
what we have known and what this
Like
book
I said,
puts
we have
out and what we
sabbatical.
have been
I hope you all
told
had a real
by
good Christmas
lawyers
and
that
Happy
have been
New Year. I hope
retired,
this year works out better.
by
and a lot of
lawyers
the
who never
rumors
got
that
their
is
bar card because they were
out here
disappointed because when they went through
what
this,
is
they
going
were
on
never taught law.
About
That right
the
there
new
is the key
republic,
issue,
coming
ladies
in.
and gentlemen.
I hope that it does.
They
Because we
were
need
never
a change, but it's going to
taught
take you people to do
law.
it. I want to
They
thank
were
you for
taught
being in here
theory.
tonight, and you guys all have a good night.
They were taught.
Thank you, Rod.
Concept.
Thank you, everyone.
Thank you, Harvey. Good night.